Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City, as well as anyone who may be joining us in Las Vegas, and of course, anyone watching online through Nellis or our YouTube station. With that, Committee Secretary, will you please take the roll?
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Hanson. Here. Hardy. Here. LaRue Hatch. Marzola.
Present.
Moore.
Here.
Nadeem.
Present.
Orntlicker.
Here.
Roth.
Here.
Urick.
Here.
Chair Miller.
Here, and please mark Assemblymember Gray present when he arrives and Assemblymember LaRue Hatch absent excused. With that, just a few reminders. I ask that everyone turn off their electronics to not be disruptive today during the hearing. Also, a reminder that we ask that presenters keep their presentations to 15 minutes, and anyone speaking on either testimony or public comment today, keep their comments to 2 minutes. We will have public comment today at the end of the meeting. I also ask that anyone speaking today make sure that they state their name and spell it so that we have it accurate for the record. Today's member ID is listed on the agenda that you can also see posted on Nellis. And we actually had a few more bills scheduled for today, but those sponsors all pulled their bills, so we're down to one today. With that, the member ID today is 888-475, the phone number is 888-475-4499, and the member ID today is 850-7638-9225. And with that, we will go ahead and get started with our bill today. I will open the hearing for Assembly Bill 275. It revises provisions relating to criminal procedure. Assembly member, whenever, I'll give you a few moments to get settled, and then you all may introduce yourselves and proceed.
I'm ready. Good morning, Chair Miller. I appreciate the time and my esteemed colleagues on the Judiciary Committee. For the record, I'm P.K. O'Neill, Assembly District Representative for District 40, representing Carson City, Story County, and parts of Washoe County. Sitting with me today is Todd Williams, Chief Deputy District Attorney, and Peg Samples. Today, it's my pleasure to present to you Assembly Bill 275, which seeks to ensure that juries have full, complete, and accurate information in cases concerning Nevada's smallest and most vulnerable victims. It is narrowly tailored to apply only to child sexual abuse cases. Under current law, when a child or their family member confronts their abuser via telephone, any law enforcement officer present must take notes to document any statements of the defendant. At trial, the officer's testimony is based upon their notes and memory of that conversation. Assembly Bill 275 creates a narrow exception applicable exclusively to child sexual abuse cases to Nevada's general rule that telephone calls may only be recorded with the consent of both parties. It will ensure that Nevada juries make decisions based upon the best evidence regarding statements made by defendants and their conversations. And Chair, with your permission, I'd like to go through the bill quickly before we move on. Section 2 of the bill defines which offenses constitute sexual abuse against a child. Section 3 of the bill provides that in child sexual abuse cases, only a peace officer or a person acting on a peace officer's direction or request may intercept, listen, or record a communication for the sole purpose of investigating a sexual offense against a child. It also narrowly defines the term person to mean that a child or person or parent or legal guardian, and this is where we have an amendment that you all should have in front of you and will be uploaded to Nellis. It came in late last night, and I apologize for that, Chair. Yesterday was sort of a hectic day, to put it mildly, between the outage and a few other challenges we had. But I'd like to have you note that the amendment states in Section 3, lines 13 to 18 to read, where one party to an electronic or oral communication consents to the interception, listening, or recording of a wire electronic communication by a peace officer or person acting. But it's that first part that is the amendment that we're proposing. Then Section 3 of the bill provides that in child sexual abuse cases, only a peace officer or a person acting in the peace officer's direction may request the interception. Please note that the conceptual amendment in this section, as we stated, clarifies that it's only a one party to the phone call. The victim, their parent, or legal guardian must consent to the recording. Section 5 simply moves the definition of sexual offense of a child to the beginning of the statute. I would now like to turn some time over to Washoe County Detective Todd Williams. He has a short PowerPoint, and then the Washoe County Chief Deputy District Attorney Peg Samples to explain it, and we'll be ready for questions at that time.
Good morning, Assembly members and Chair Miller. Thank you for your time. My name is Todd Williams, Toddwilliams. I'm a detective with the Washoe County Sheriff's Office, and I'm assigned to investigate crimes against children. We have a brief PowerPoint presentation to go over this bill and why we believe it is important. This bill is about child crimes, and it'll change NRS 179.463. The proposed change. We propose a change that would allow Nevada peace officers, with consent of one party, to record telephone communications for the sole purpose of investigating a sexual offense against a child. Why? We believe it empowers child victims of sexual abuse to confront their abusers. These recorded communications are widely used around the nation to assist in solving and adjudicating cases of child sexual assault. It ensures the prosecution, the defense, the judges, jury, and appellate courts are presented with accurate recordings and not just relying on law enforcement and or witnesses' testimony or statements or reports. And also, Nevada is one of the most restrictive states in the nation when it comes to recording a telephone call. This all came to be when my colleagues and I attended the San Diego International Conference on Child and Family Maltreatment back in 2024, at the beginning of 2024. During this conference, we met with investigators, prosecutors, and judges from around the world, and we had an open forum discussion specifically on pretextual phone calls and their use in child sexual abuse cases. We found that Nevada is one of the most restrictive states in the entire nation, with only 10 states having the same laws as Nevada, where it is a two-party consent or all-party consent state and does not have any law enforcement exemption. The other states that were present during the forum spoke about a 50% success rate in getting admissions and investigation and gaining valuable investigative information from these pretextual phone calls. We came up with a few case examples. I just want to let you guys know that the case examples contain graphic information. However, they are essential to understanding the necessity and impact of AB 275 and why we're here discussing it today. These case examples, we have one from San Diego, from the San Diego District Attorney's Office, who has been remarkable in helping us get this far. Additionally, there's a case here locally out of Washoe County where the main difference would be San Diego is allowed to record their pretextual phone calls and we are not. Case number one, a 5-year-old girl disclosed to her mother that her biological father made her perform oral sex on him by promising to give her a lucky dollar, but he never gave her the dollar. She said that he made her perform oral sex more than once, but because of her young age, she had a difficult time explaining how many times it happened, when the acts occurred, or details about the acts. Even though this is common for very young children who lack the development to understand time and numbers, the defense will usually use this against the prosecution to argue that the child is not credible. We had no other evidence of abuse such as DNA, witnesses, prior history of sex crimes, etc. However, in a pretextual call, the girl's mother confronted the defendant and he admitted to putting his penis in her mouth and explained that he was using meth, which turns him into a pervert. He ultimately pled guilty and was sentenced to 30 years in prison. I would like to turn it over to Chief Deputy District Attorney Peg Samples for the local case.
Good morning, Peg Samples, P-E-G-S-A-M-P-L-E-S. I'm the Chief Deputy District Attorney currently at the Washoe County Child Advocacy Center. Just for a brief Washoe County example, we did have a case involving a 40-year-old man. He was commonly used as a babysitter by two mothers. Both of them were single mothers. They both had 11-year-old children. He subjected both of the 11-year-old children, the little girls, to repeated sexual abuse. One of them finally worked up the courage to tell her mother after a long period of time. Her mother reported that to the Sparks Police Department. One of the first things that the Sparks Police Department did is use the mother to make one of these phone calls to the defendant. It was not recorded, obviously, but it was supervised by a detective. The defendant did make admissions. There were other parts of the investigation, but the case did proceed to trial. Obviously, a big part of the state's evidence was the victim's testimony, but another part was that detective testimony and the mother's testimony about that recorded phone call. The defendant was convicted of 10 counts of sexual assault on a child and lewdness with a child, so that phone call became an important piece of the puzzle.
That, Chair, I think we made the 15-minute limit, and we now stand for any, actually sit for any questions that the committee may have. Thank you.
Thank you so much. Our first question will be from Assemblymember Roth.
Thank you so much, Chair, and thank you so much for the presentation. Trying to formulate my question because obviously the first thing that comes to my mind is the Fourth Amendment. So can you walk me through why this is not already an exigent circumstance or why this should fall outside of the warrant requirement?
Yes, Peg Samples, thank you so much for the question. Since it's not a search or a seizure, we're outside the scope of the Fourth Amendment. We do have exigency circumstances that are currently codified into our wiretap statute. And one of them is not child sexual abuse. The exigency circumstances in our wiretap statutes, which I think is maybe the call of your question, and if not, I'm happy to clarify or listen to a follow-up question. But the exigency circumstances in our current wiretap statute are things like if somebody's holding someone hostage or is barricaded in some sort of building. In terms of the need for this to not be a warrant and the reasons why that is sort of burdensome, I can turn it over to Detective Williams to clarify that.
Todd Williams. Currently, Nevada statute says for wiretaps that we must have exhausted every possible opportunity to do this or to get a wiretap warrant, and they are very, very costly. In fact, I believe no agency in the state of Nevada has the ability to set up a wiretap. The last time that we attempted to use one on a very different case, we had to use Homeland Security, and it cost thousands and thousands of dollars. Additionally, with the statute stating for us to apply for a wiretap warrant that we have to have exhausted every possible lead, that would mean having interviewed the suspect, which would completely void and get rid of the point of these phone calls.
Peg Samples one more time. And another concern with a wiretap is it captures and records everybody who is calling that phone. That's the subject of the wiretap, not just the suspect, not just the victim or a victim's non-offending parent. So it is actually broader and goes more into interfering with privacy rights of people who have nothing to do with the investigation.
Thank you. Just for clarification, if we can take a step back. So this is a search and seizure under the Fourth Amendment. And so is there a reason that obtaining a warrant is not reasonable in this case?
Again, what we would have to do is obtain that, a wiretap warrant. Those have to be obtained through, with the approval of a district court judge or a Supreme Court judge. They do not work 24/7. These investigations are going on 24/7, and so one of the reasons, as Detective Williams said, is it's very expensive, it's time-consuming, but it's also lacks a bit of practicality.
I'm sorry, could you repeat that last statement? What lacks a bit of practicality?
The requirement to get a warrant, just because obviously these investigations are done around the clock. Getting a warrant requires, and a wiretap warrant requires a Supreme Court judge or a district court judge's approval. And so if you have a case where you need to make one of these phone calls when a suspect gets off of work, for example, at 2:00 in the morning, that's not practical to get a Supreme Court judge or a district court judge on the phone or in person to approve one of these warrants.
Okay, thank you. Our next question is from Assemblyman Urick.
Thank you, Chair, and thank you all for the presentation. And really thank you, detectives, for what you guys do in this space, just by the examples you gave. That is a difficult space to operate in, and so thank you for the courage that it takes to do those types of investigations and deal with some pretty horrific facts. So if I understand correctly, federal law allows one-party consent recording of conversations, but there are certain states that apply stricter requirements and require two-party consent for recording these types of conversations. Just to help put it in perspective, can you clarify how many states currently go further than what federal law requires and actually require two-party consent?
Thank you, Assemblymember Urick. Yes, currently there are, Todd Williams, for the record. Currently there are 10 states that require two-party consent and are more restrictive than the federal government. The federal government does allow one-party consent when it comes to recording telephone calls.
Thank you. Our next question is from Assemblymember Dahlia.
Thank you, Chair, and thank you for the presentation. I have a question about the usage limitations on the recordings obtained for this purpose, because it seems from my reading of the language that as long as you're intercepting it for the sole purpose of investigating a sexual offense against a child, I don't read any usage restrictions on how that can be used if you end up getting something in that recording that could be used for another criminal prosecution. So can you talk to me about what you imagine would be the guardrails for that? Thank you.
Yeah, I imagine that it would definitely be used in a criminal prosecution as evidence.
Do you need to follow up? Okay. Our next question is from Assemblymember Hanson.
Thank you, Chair. And certainly I wish you two were unemployed. But again, as my colleague said, thank you for what you do, really hard work. I'd like to know, how do these telephone conversations affect the victim? If you could maybe elaborate.
Thank you so much for that question, Peg Samples. I want to go back a little bit in time to 2021, 2 sessions ago. This committee actually started a bill, AB 228, that codified and defined what a child advocacy center is. Part of that was to define what the goals of a child advocacy center are, and those are now in law in 432B.4012. So the two goals are, first, to investigate and help children recover from abuse and neglect. When a child who has been victimized is able to finally work up the courage and throw off the cloak of secrecy that sexual abuse happens in, and tell someone about it, but then also participate in their own investigation, it has immeasurable effects for the recovery from their trauma. And so I think that that's a very, very important goal of AB 275. I think that this, if passed, can be one more step in the recovery of children who've been sexually abused.
Thank you for that. And my colleague actually asked a question that I had as well about the actual victims, the children. And so you stated that the agencies spoke about this, but this being such a sensitive issue for children, are there counselors that are involved in this process? Is there someone from the medical or mental health that would say that this would be appropriate or okay for the child? Because again, when it comes to, facing or participating in this, I also see the reverse, how it could be very damaging and scary. So what type of research or consulting has been done on that front?
Thank you for the question, Peg Samples. The cases that would use these types of phone calls would primarily be routed through and investigated in conjunction with the Washoe County Child Advocacy Center and other child advocacy centers in our state. Every child who comes to the Washoe County Child Advocacy Center has access to immediate mental health counseling and continuing mental health counseling. There is a number of factors that would be considered by law enforcement before they use a child in one of these or a series of these phone calls, and I can let Detective Williams address those further.
Chair Miller, thank you very much for the question. Todd Williams. When we have used these before, so just to clarify, this is currently done in the state of Nevada. They are just not recorded. That's what this bill is trying to do. We take every precaution. Ultimately, we're in this job to protect children and make sure that they're getting the help that they need and that they're not continuing to be re-victimized. So from the very start of when we take the initial case, we have victim advocates that work with the child and their parents to make sure that they're in a good spot and that they actually want to proceed with criminal charges in this investigation. We do not necessarily always use the child. Sometimes we use the parent or the guardian, depending on where the child is at mentally, where they're at in the recovery process. There's a lot of things that come into play, child's age and numerous things. I can't give you a specific there's no set in stone answer as to who this is best for. We take it case by case.
Thank you so much. Our next question will be from Assemblymember Cole.
Thank you for that clarification. I think that actually partially answered my question, because I'm looking at this. It's already happening. You said you've used it and successfully in a trial, just you didn't have the recording. So the way that I look at it actually provides some protections to the defendant as well, right? So that it's clearly documented. There's no question as to whether or not it was taken out of context. So to me, would you agree with that it does provide protections?
I'll let Peg Samples answer here in just a second. Todd Williams for the record. Yes, absolutely. I think the major importance with needing the recording is currently we require 2 detectives to sit into the room when we do this. One detective is the primary case agent, and then another detective is a witnessing officer. We take notes as quickly as we can to best memorialize the conversation that's documented, but there's things that we are not able to accurately get into a report or a statement, and that's tone of voice, pauses, inflections, attitude, things like that are not easy to put in black and white on pieces of paper.
Peg Samples, thank you so much for your question. I absolutely think that this protects defendants as well. If these recordings are used at trial, we have to kind of come to the uncomfortable topic of how long sometimes it takes to get to trial. So after the investigation, during which these recorded calls would be part of the investigation, it can take years to get to trial. And so by that time, memories have faded. no matter what, no matter who is testifying. And so to have it on recorded tape is much more accurate to both parties, yes.
Thank you. Our next question is from Assemblymember Gonzalez.
Thank you so much. Good morning. Thank you so much for being here. So, just for clarity, because I feel like in some answers you've kind of walked through it, and then in other answers we've just had partial. So, can you just walk through how you are currently operating, and then also can you talk about that case that did go to trial and how you used it in that case, and was the person convicted or not?
I will start from, I'll cover the investigative portion. I'll give it to Chief Deputy District Attorney Peg Samples for the trial portion of it. So currently, we take an investigative case. There's quite a few things that we take into account when we decide whether or not this will be a good investigative tool for a case or not, whether or not the defendant knows where the child is at in their recovery process and things like that. There's a lot that goes into account. And like I said, it's very case-by-case basis. But when we do it, we strategize with the child and or the parent and talk about how we want to cover it and what the goal is, what the disclosure was that was made by the child. And ultimately, we schedule a time, whether that be at the child's house or at the sheriff's office or a mutual place. We figure out the best time that it's going to happen, right? And then we either begin by a text message conversation with the suspect and or just calling the suspect. These conversations are never audio recorded, right? Text messages are a little bit different because they're memorialized on a phone, but they're never audio recorded. And so it takes two detectives sitting there, and we basically have previously covered what the goal is that we're trying to speak about with the suspect, right? We strategize with the child and or the parent, and then we just try to keep them on track to get them to where they're talking about the specifics of the disclosure that was made, whether that be that it's inculpatory evidence that's gathered or exculpatory evidence that's gathered. And then ultimately at the end of the day, we in the conversation, and then there's other investigative steps that have happened. I can speak for a case that my agency investigated a few years ago where a child found a cell phone recording inside of her bathroom. Ultimately, she discovered that it was her mom's boyfriend's cell phone. She went to her mother and informed her of this cell phone that she found. The mother decided to stay with the boyfriend. She gained the courage and eventually told law enforcement about this case. We took a case on it, and we found that a pretextual phone call would be a good strategy, and the child was in a good place to do that. We did the pretextual phone call at the sheriff's office, and during that conversation, the suspect admitted to what he did and apologized to her, and then kind of guilt-tripped her and said, "My life's in your hands," and things along those lines. There was two detectives present for that memorialized that in reports. Later, the conversation ended later down the road. The suspect was brought in for an interview, and during the interview, he denied. He said, absolutely not. The child's disclosure is inaccurate, it's false, never happened, until we were able to use the pretextual information that we gathered from that, and then he changed and it ultimately admitted. He pled guilty in court and was sentenced to 1 to 5 years. As for how it normally plays out, I'll give it to Chief Deputy District Attorney Peg Samples.
Thank you, Peg Samples. So when a case proceeds to jury trial, generally how these cases go is the victims will testify first, and then we call in sort of some of the corroborating witnesses. So in the case that I spoke about in Detective Williams' introduction, both of the 11-year-old children testified. I believe the mother who had done the recorded phone call with the detectives testified and was asked questions about that phone call, and then the detective testified and again was asked questions about the contents of that phone call and the statements that the defendant made during that phone call. It was similar to the the case that Detective Williams just talked about during the investigation. The phone call was one of the first pieces of the investigation, but then detectives actually went out and interviewed the defendant, confronted him with some statements that he'd made during the phone call with the mom, and proceeded to get more inculpatory statements from the defendant. That case was a jury trial. The jury did find the defendant guilty of 10 counts of various crimes involving sexual abuse against those two girls.
Thank you so much. And I'm so sorry if I missed this in your presentation, but when we're talking about child, is there a specific age range, or are we talking, 11-year-old and a 4-year-old are very different developmentally? So I was just curious, is there a specific age that we are talking about? Thank you.
Todd Williams for the record. Again, yes, I don't believe a 4-year-old would be just, I can say that. I don't think a 4-year-old would ever be in a place where this would be a useful strategy. However, I think we have to leave it open. When we refer to child, it's anyone 17 years of age and younger. And whether or not it's the parent or guardian that makes the phone call and or the child is case dependent and age dependent. There's, like I said, a lot of things that come into play on whether or not we believe that it's better suited for the child or better suited for a parent or guardian to make the phone call.
Our next question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. So my question is that, as you mentioned in your presentation, two factors that can that leads to consent of the party. What are those factors, and what is the one consent factor?
Todd Williams for the record. Thank you for the question. Two-party consent or all-party consent, which that it's known otherwise, is basically stating that all people that are on the phone call must consent to the recording. This does not work in these cases because obviously if we told a suspect when we were making a phone call, hey, we're going to record this conversation, are you okay with that? They're not going to make any admissions on the phone, or they're not going to be truthful, right? That's what we're on. That's what we're looking for is the truth. One-party consent is basically stating the parent or guardian or the victim themselves are able to consent to the phone call being recorded.
Okay, thank you.
And I would just like to clarify for everyone that the one-party, two-party issue is not just specific to this bill or this issue. It's anytime we're on the phone for any reason recording or no matter what it is. With that, our next question is from Assemblymember Orntlicker.
Thank you, Chair, and thank you for your presentation. So I think I'm pretty clear on your concerns. I'm having trouble going from your concerns to the bill language. So let me give you a couple reasons why. One, you've talked about the practicalities of getting the warrant. You might have to call the judge in the middle of the night. But all the examples are pretextual calls, carefully planned over a period of time, which would seem to give you opportunities to get to a judge in normal working hours. You've also talked about the standards for getting a warrant, and I've looked at those, and NRS 179.470, and they don't look as onerous as you've described, but maybe you're describing how they're applied rather than how they're written. So I appreciate there can be differences. But if that's the problem, NRS 179.470, I'd expect you to have a bill saying, let's tweak or revise these requirements for a warrant rather than getting rid of a warrant altogether. So if you could elaborate on why we need to go as far as you want to go rather than something that's more respectful of criminal due process rights.
Thank you for the question, Peg Samples. I'm not sure if AB 275 is going so far. As Detective Williams has testified, this is already a well-established legal investigation process. It's just that we want to record these conversations in the future. I will say I do fully respect a defendant's due process rights, as every prosecutor should and does. The main, I think, thing, though, is we need to also think about a victim's rights. So victims, obviously now pursuant to our Constitution, have rights under Marcy's law. I have seen these cases go to trial, and I've seen the victim be cross-examined on not only on whether the abuse happened, but then when they've engaged in one of these conversations with the defendant, where the defendant has made admissions, they've been cross-examined about their recollection of that that phone call. And so I do understand that it's a balance between victims' rights and defendants' due process rights, and that's why this bill is very narrowly drafted and only applies to cases involving child sexual abuse.
So yeah, so I appreciate it's narrowly drawn in that sense, but I still haven't gotten why you feel you can't go to a judge at all. You don't think a judge has any role in this. That's what I don't get.
I would like to thank you for the question, sir. Todd Williams for the record. Again, as you've stated, the language in that statute states that we must have investigated or tried every investigative step. And currently, the process of wiretapping or completing a wiretap is very, very costly. And it takes months to set up with Homeland Security. And it records, sorry, it doesn't record. It monitors every phone call that the suspect makes. And then there's a specific time it has to be monitored by person and actually recorded at the time that the phone call is made. I would like to say that we could narrow it down to a specific minute or hour, but unfortunately, like when we set these up, there's times where somebody is busy and can't make it, something's come up, and we've had to reschedule them. And just with the time that it takes to get Homeland Security, who's the only agency that I know of that's able to do this, involved, they have to have a federal case that they want to sink their teeth into as well, if that makes sense. Like, there has to be something that Homeland Security has an interest in. They don't just do it just because we need them to. There has to be like a federal nexus. And there's not always a federal nexus in these cases.
We'll move on because we still have others, but I'll come back to you. Our next question is from Assemblymember Moore.
Thank you, Chair, and thank you for the presentation. I do have a question about the wiretap warrant that you mentioned, and you also said that you have to go through Homeland Security to get the wiretap going. Can you walk us through the process of obtaining a wiretap warrant?
I can, Todd Williams for the record, thank you for the question. I can do my best. I have not actually done a wiretap warrant, so I'll do my best to elaborate on it that was used in our office. The statute states that the district attorney themselves must apply to either a district court judge or a Supreme Court justice on the necessities to a wiretap, and then there's a lot of stipulations in the NRS that talk about what the justice must take into account when it comes time to actually grant the warrant. That's what I can speak about. I can speak about the difficulties with the actual execution of it, if that's what you're asking. Sorry.
I was asking about the process itself, because earlier it was mentioned that it's very difficult to get a wiretap warrant. So I was curious to see what the actual process looked like, how long it takes, and also at what point do you is it the DA's office who decides that this must go through the district court judge or the Supreme Court justice?
PEG samples, yeah, it would probably be the district attorney that would decide whether it was a district court judge or a Supreme Court justice.
And we're not just talking about Washoe and Clark County, where there's multiple judges and multiple district attorneys and assistant DAs. You go to White Pine, you'll have one district court judge who actually covers multiple counties. You'll only have the one DA and maybe a part-time assistant. I will admit I have been retired from law enforcement for 15 years. And when I was working cases, which included child abuse cases, sexual child abuse, we could plan on being every bit of 4 to 5 hours going through the affidavit, proofing it, getting it to the district attorney, having them make comments on it, getting the judge to read and sign off on it. And then it would usually be for a set time. The person didn't answer the phone, wasn't available, and we'd have to start all over again. And the difference now, particularly when I did it, it was a hardline phone calls where they were much easier to set up. We just use a suction cup basically on the speaker side. Now the cell phones and what that has added has greatly complicated, and I think that's the part where it has to have that federal, the Homeland Security brought in to have the technical equipment to intercept these electronic transmissions. That helps you at all, Assembly Member Moore. Thank you.
Thank you so much. Our next question is from Assemblymember Urick.
Thank you, Chair, for the follow-up. This is, I think, primarily going to be for the DAs because I'm hearing a lot of talk about warrants. And as a prior law enforcement officer, and I actually have sat on wire intercepts and have undergone the challenges and the logistical issues that I think are being discussed by my colleagues on the dais today. And I guess to preface this, and I'm hoping maybe you can speak to a little bit more to address some of these concerns, is certainly we all respect and want to honor the Fourth Amendment and people's right to be free against unreasonable searches and seizures. And certainly the preference or the idea that usually under most circumstances there would be a warrant that would be obtained under circumstances where you are trying to obtain criminal evidence against an individual to be used against them in court. However, despite that preference for that, there are well-established and delineated exceptions to the search warrant requirement, one of which I understand to be one-party consent phone calls, that this issue has been addressed and established by our United States Supreme Court, indicating that where an individual is subject to this sort of one-party consent recording, that the admissibility of that evidence is absolutely okay, even absent a search warrant, because an individual that is on the phone has what I think the courts refer to as a diminished expectation of privacy. When you are on the phone with another individual, the government isn't intruding any more into that conversation to obtain information than that which that individual has already voluntarily provided. So can you address perhaps the issue of the well-delineated exceptions and how the one-party consent plays into this?
PEG samples, yes, thank you so much for the question. Our United States Supreme Court has said that one-party consent statutes do not violate a privacy right or the Fourth Amendment. So obviously, as this committee knows, state legislatures can give more protections, but not fewer protections than the United States Constitution. And so that is why Nevada is able to make ourselves a two-party consent state, along with I think Detective Williams said it was only 9 other states that do that. But Assemblymember Urick, you're absolutely correct.
Thank you. Our next question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. So for the better understanding, in case of sexual abuse of a child, if the child is young, how the child is communicate on the phone and why the suspect is going to say things that's going to expose him while the phone conversation.
Todd Williams for the record. Thank you for the question. a lot of times they do it in hopes of not getting in trouble, whether they own that and acknowledge that they victimized the child in hopes of, like I said in the previous case, almost guilting the child into not wanting them to further disclose to law enforcement. Typically, we use these in cases where the suspect has not been notified or tipped off that law enforcement has been involved. I think that probably best answers your question, I believe.
Sure, yes, thank you.
Assemblymember Nadine P.K. O'Neill, for the record, if I may add, as I said, from my own personal experiences, listening in on phone calls, it would be very often, if you say anything, the offender, subject, would say something like, Julie, if you say anything, we won't be able to go get ice cream anymore. This is a personal secret that just between you and me and how much we care for each other, and we don't want anything to involve them. And as was said, guilt the child through this coercion. And it's those inflections, the tones, the way it's even delivered in the timing of the delivery of the message to the child, that care that is shown by them. That is so important, I think, in recording it instead of just taking notes. And as has been said before, it also protects the subject for the defense. I mean, it's a true and accurate record. Does that answer your question for you with additional? Thank you. Thank you.
Thank you. So I have a follow-up to my colleague's question. So these days, how many cases do you find are where the predator has gone after the child verbally over the telephone versus the other means that we know that children and youth are communicating through social media, through video games, through any other online or internet? How much is actually verbally speaking on the phone versus those?
Todd Williams, for the record. I just want to clarify your question. Like, how often do they make admissions on the phone? Is that what your question is?
Just in general, reaching out, communicating, whatever term you want to use, but I'm just looking for how much is verbal communication over the telephone versus any other form of texting or communicating through the video game, social media, anything online or internet-based.
Well, I can say that, sorry, Todd Williams again for the record. I can say that in today's society, everyone, I think the last statistic that I looked at was 90% of Americans use their cell phones. Whether that's we're investigating juvenile offenses or a juvenile on an adult case. Cell phones, I can't even tell you the last time it didn't play a part in the case, whether it be text messages, videos that were shared. There's always some kind of nexus with electronics and cell phones. It's just so common.
So my question is, can you tell me the number of cases or investigations that we have that are based on verbal communication over the cell phone or landline or any phone versus other means of communication, meaning social media, video games, internet, texting?
Todd Williams again for the record. No, I cannot tell you that statistic. I can tell you that when we usually these cases are involve actual physical, like in-person contact where a crime was committed or is alleged to have been committed, and then we use this tactic to find the evidence, exculpatory or inculpatory evidence. Whether or not they had conversations prior to that incident on the phone isn't always the case. Oftentimes, the victim will have disclosed something to the parent, the non-offending parent, and the parent will separate the two of them, whether the suspect actually understands why or why not. But there's that gap there, and then the only way that they are able to communicate is through electronic means.
Our next question is from Assemblymember Roth.
Thank you so much, Chair. So I just want to make sure, I kind of take a step back and make sure I'm understanding the intent of the bill. So this is not a wiretapping bill. This is to allow recordings of phone calls without a warrant. So can you explain, outside of the wiretapping statute, right, because it doesn't amend that statute, why not allow for one-party consent of these phone calls with a warrant?
Peg samples, the way that the laws read right now, I'm not even sure if a judge outside of a wiretap warrant request could legally grant a law enforcement officer the right to record a phone call, because Nevada is that two-party consent state. The way that law enforcement gets around the two-party consent state rules now is by getting that wiretap warrant. Not a regular warrant.
Thank you. And I think, what we're just trying to get at is the concern here is that this takes these phone calls, which can be sweeping. There could be all sorts of information, private information that's brought up on these phone calls outside of the warrant requirement. And so I'm just trying to understand, is there a way to narrowly tailor this so that a warrant is still required to amend the statute so that we are still ensuring that people are protected, that there is judicial oversight into one of the most invasive things that a government can do, instead of just completely taking this outside of the warrant requirement?
Peg samples, that's a good question. Probably, but I would also note, obviously, if this bill passes and we are allowed to record these conversations in the future, again, the bill is narrowly tailored just to apply to child sexual abuse cases. But we still, if we're going to admit that in court, we still have the normal rules of evidence. And so if things are talked about that are legally irrelevant or are inadmissible on other grounds, then that would be the subject of litigation and judicial oversight.
Thank you. Assemblymember Gonzalez, yes.
Thank you so much for the additional question, Chair. In reading the bill, it does not define electronic communication. So I was just curious what the intent around that is. Does that include a Facebook phone call, an Instagram video message? Can we talk a little bit about that? Thank you.
Todd Williams for the record. Thank you. That is a great question. Yes, it would be all recorded, like voice conversations, if that's the easiest way to put it. So phone calls, Facebook phone calls, Instagram phone calls, all of the above, that is voice to voice.
Thank you. Would this include video? Because all of those that you mentioned can also video record as well.
Todd Williams for the record. The way that we utilize the recording, or how we plan to use the recording, is actually like an audio recorder. So it would not capture any actual video.
Thank you. And our final question comes from Assemblymember Ortlicker.
Thank you, Chair. I was going to ask what Assemblymember Roth asked about the judge for recording. So it did sound like you said that would work for you if we change the law to just allow you to get a recording with the warrant, and then you wouldn't have to go to Homeland Security and have an expensive wiretap. Did I hear that right?
Peg samples, I'm not sure, because the law as written now says that it's illegal to record. There's no provision except for the wiretap, even with judicial intervention or even with a warrant that's granted by a judge. Our laws as written still make Nevada a two-party consent state. Like I said, the only exception is with the wiretap warrant.
Yes, please.
Okay, so I appreciate right now, but you could ask us, we could see a conceptual amendment that said, please give us authority to get a recording, one-person consent recording with the approval of a judge. We could have that conceptual amendment, is that correct?
PK O'Neill for the record. I appreciate the question, the conversation, and not being an attorney, not even practicing, not playing one, having tried to stay as far away from the legal system since I retired in law enforcement, I would imagine that would be, I think it would be a better question answered by LCB Legal. I mean, I could give you probably the set answer of, in the legislature, we can do anything we want and let the courts figure it out later if it's appropriate or not. And we have done that in the past. And we have been wrong. We have been correct in our actions. So that's a very abstract, theoretical question that I don't think I can answer properly for you. Thank you, sir.
Well, I do appreciate your support of the three-branch system and the separation of powers. So with that, we will go ahead and close our questioning, and we will open it up for testimony. Starting here in Carson City, I will open it up for testimony in support of Assembly Bill 275. Again, I ask that anyone testifying keep their comments to 2 minutes. Also, please remember to state your name and spell it so that we have it for the record.
Thank you. Good morning, Chair Miller, Vice Chair Marzola, and members of the committee. Jennifer Noble, Jennifer Noble, testifying in support of AB 275 on behalf of the Nevada District Attorneys Association. I also sit before you as an appellate attorney. This has been my area of practice, specifically constitutional criminal law in the appellate setting for the last 13 years. And part of that is being familiar with the Fourth Amendment, those fundamental protections, and the well-established exceptions to those fundamental protections. And one of those, in one-party recording states, is one-party consent recordings, with the rationale being that when you make a phone call to somebody else, there's no additional government intrusion because you are voluntarily talking to another person with no assurance that this is a private conversation any longer. And this is why 40 states allow what we are asking you to do today. The alternative to this is to have jurors continue to rely upon the notes that the officer takes during these conversations. This information, these conversations are getting to the jury, but through the filter of law enforcement's, and I'm sure they make their best efforts to be objective, but through their memory and their notes. That's the information. Those are the statements that are getting in front of juries. So what this bill does is it protects the defendant, and it protects the prosecution, and it makes sure that the best evidence is getting in front of that jury, and there's no filter about what statements the defendant made. We are not talking about tapping someone's phone without their consent. What we're asking for is the ability to record conversations with the consent of the victim, their guardian, or their parent, with their consent on their end. So what we're asking for is an exception to Nevada's two-party recording statute for this narrow purpose of child sexual abuse cases, and I urge your support of this bill. Thank you.
Good morning, Madam Chair, members of the committee. Jason Woodard, Jason Woodard, Nevada Sheriffs and Chiefs Association. We're in strong support of this bill. What this bill does is it enhances an investigative tool to be used by investigators in cases that are wrought with challenges. These cases often involve delayed reporting, the lack of physical evidence, multiple offenses by the offender upon the victim, and the offender is oftentimes a caregiver known to or trusted by the victim. These investigative tools, recorded pretextual phone calls, are used in 40 states, one of those states being California. California is a two-party consent state. However, they have long had a law enforcement exemption that specifically allows them to record these phone calls. Pretextual phone calls are used on a daily basis by investigators here in Nevada. The only difference is they are not currently recorded. Recording these calls is the single most effective way to accurately depict the statements made by the offender and their own voice, tone, and inflection. And let's not forget, the offender always has the opportunity to not talk, not answer the phone, or to terminate the phone call. Now, I can attest as an investigator of these cases, also as an instructor in investigations and a 26-year law enforcement veteran, to the effectiveness of these pretextual phone calls. The most significant thing about these pretextual phone calls is they also give an opportunity for the victim and their family members to take an active role in the investigation and seeking justice for the wrongdoings this offender has committed upon them. We strongly support this bill. We thank Assemblymember O'Neill for bringing it forward, and we'd ask that you do the same. Thank you.
Good morning, Chair and members of the Judiciary Committee. My name is Joshua Martinez, Joshua Martinez, representing the Las Vegas Metropolitan Police Department. I want to echo many of the statements that were made by the prior speakers. This would be another tool for us in our investigative toolbox when we investigate these heinous crimes. So we ask your support of AB 275. Thank you.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, C-A-T-H-C-A-R-T, representing the City of Henderson. We want to thank the sponsor for bringing the bill. Unfortunately, all law enforcement agencies must deal with these types of cases, and this legislation would be helpful in those investigations. We agree with everything that was said by the Nevada Sheriffs and Chiefs and the Nevada District Attorneys Association, and we are in full support of the bill. Thank you.
Thank you so much. Is there anyone else wishing to make a support testimony here in Carson City? Is there anyone in Las Vegas? Broadcasting, will you open the lines?
If you would like to testify in support of Assembly Bill 275, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 275, please press star 9 now.
Good morning, Madam Chair and members of the Judiciary Committee. My name is Eva Kilombian, spelled Eva-Kilamyan. I have been a prosecutor in San Diego, prosecuting child abuse cases for 11 years. I'm calling, strongly supporting this bill. As someone who has used these recorded phone calls, I can provide some insight from my end on some things that are missed in a report that we can get in a phone call. Often there are nuances in phone calls that can be missed. For example, if someone is saying, I'm sorry in a phone call, I'm sorry can mean I'm sorry for abusing you, but it could also mean I'm sorry that you're feeling hurt. And these nuances are difficult to capture in writing, the same way that they would be in a recording that you can listen to over and over to determine what the person really meant when they said something. Oftentimes, phone calls can also be have various nuances in them that you would need to listen to over and over to understand what somebody meant, especially in complicated cases where phone calls can take 45 minutes or an hour. This has been used many times in my cases, and I have achieved very favorable results based on being able to record these phone calls. Thank you very much for your time.
Thank you. Next caller.
If you have recently joined and would like to testify in support of Assembly Bill 275, please press star 9 now to take your place in the queue. Chair, there are no other callers wishing to testify in support at this time.
Thank you so much. Then I'll go ahead and open it up for opposition testimony, beginning here in Carson City.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELA-KNOTT. We are in opposition to AB 275. We all agree that the best interest of the child should be our priority, but this bill risks placing children in a harmful position where they are forced to relive traumatic experiences during the middle of an investigation and be used to incriminate their parent. That seems like a lot of pressure for a child, especially a child who probably just wants to please an authority figure like a police officer or their other parent. And I can't think of a scenario where I'd put my child in that position. The potential for abuse under this provision is alarming. Without the requirement for probable cause or judicial authorization, this bill could lead to overreach and surveillance that targets innocent individuals. It fundamentally shifts the balance away from protecting individual rights and toward unchecked government power, and this is not the society we want to build. The pre-existing exceptions to warrantless interception are situations where there is imminent threat to life and fit into the exigent circumstances exception, like when there is a hostage situation. The same cannot be said for AB 275. The example used by the presenters involves detectives with the victim and the parent. They are in the middle of an investigation. They can use that probable cause to get a warrant. The child is not in immediate danger, and requiring a warrant is appropriate. A warrant ensures a neutral magistrate agrees that there are sufficient facts to justify this privacy intrusion. Any burden to law enforcement in obtaining a warrant is justified because of the constitutional protections given to all persons. For this reason, we must oppose AB 275.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-E-R-O, on behalf of the Clark County Public Defender's Office. If law enforcement has probable cause that someone is a suspect of sexual abuse against children, then they can apply for a warrant. Judges exist for a reason. They're an important check and balance in order to make sure law enforcement is not conducting surveillance without accountability. The neutral judge is the guardrail here. And judges are on call. They take warrant calls at all times, even at 2 in the morning. Two-party consent just ensures that law enforcement justify any sort of surveillance actions before a judge. Two-party consent protects everybody. The case they gave from Washoe County, they got their conviction without this law change. Allowing one-party consent risks rampant abuse and overreach. Recordings can be selective or misleading. Individuals can manipulate conversations. This could be weaponized not only in criminal proceedings, but in family law cases, misuse in divorce proceedings and child custody, because in those cases, either parent could make an allegation against the other parent, and then law enforcement can invade their privacy based upon nothing but dubious, unsubstantiated allegations. That's why warrants are important. Again, the judges are the guardrails here. We all want these types of crimes to be prosecuted, but we should not tear down the Fourth Amendment when law enforcement can easily get a warrant. And we are here to write laws, and we can absolutely change the law to give law enforcement the power that they want here, but with the protection that they get a warrant first. Thank you.
Good morning, Chair and members of the committee. My name is Kayla Maese, spelled K-A-Y-L-A-H, last name M-A-E-S-E. I'm a civil rights analyst at the ACLU of Nevada, and similar to reasons given by the Washoe and Clark County Public Defender's Office, the ACLU of Nevada also opposes AB 275. Thank you.
Tanya Brown, T-O-N-J-A-B-R-O-W-N, Advocates for the Inmates and the Innocent. Good morning. Thank you, Madam Chair, members of the committee. We are in opposition of this bill. It is an overreach. I know of 2 instances where during divorce proceedings, the child was used, tore the family apart, and I can tell you that as the years go by, they become adults. The children, they were told, they tried to correct the situation, corrected injustice, because the mother had instilled this in fear into their lives, and it destroyed everybody, and innocent people went to prison. So no, please do not pass this bill. Thank you.
Not seeing anyone else here in Carson City, and I don't believe I see anyone in Las Vegas. Broadcasting, will you open the lines, please?
If you would like to testify in opposition to Assembly Bill 275, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify. Oh, one moment.
Anne Marie Grant, ANNEMARIEGRANT, advocates for the inmates and the innocent. I just want to echo the other, my colleagues' opposition to the bill. Thank you.
Chair, there are no other callers to testify in opposition at this time.
Okay, thank you so much. Is there anyone here in Carson City that wishes to make testimony in neutral on the bill? Not seeing anyone here in Carson and also not seeing anyone in Las Vegas. Broadcasting, will you open the line?
If you would like to testify in neutral to Assembly Bill 275, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify in neutral at this time.
Thank you so much. Then I will welcome the presenters. Our bill sponsor had to leave, but I'll welcome the presenters back for any final brief remarks.
Thank you, Chair. I would just like to state one thing. That is, Nevada peace officers have been pushed for transparency for a number of years. Body camera recordings, releasing video footage, and that's all we're trying to be here more than anything, is to also be transparent when it comes time for court. We understand that there could be inculpatory evidence and exculpatory evidence gained in these phone calls, but I believe that it serves everyone and it is a win-win for everyone to record these phone calls and make it admissible in court. Thank you.
Thank you, Peg Samples. Again, just going back to AB 228, which passed, that was sponsored by yourself, Chair Miller, in the 2021 session. I just believe that this goal furthers both, this legislation furthers both goals of child advocacy centers in Nevada, which is to investigate and help children recover from abuse and neglect, and second, to hold perpetrators of abuse and neglect of children accountable. Thank you so much.
Thank you. And which bill was that I sponsored again?
Peg Samples 228.
What was 228?
228 defined what a child advocacy center is.
Oh, yes,
and
yes.
also the goals of a child advocacy center. I know that you know we were the last state in the nation to define child advocacy centers in our statutes.
Yes.
But we got it done.
Now I remember that bill. I don't remember numbers, but yes, and I carried that bill for a former Assemblywoman. So
That's right.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 275. Thank you. Thank you. And so before we move on to public comment, we do have a BDR introduction. BDR, I guess I wrote S868, deals with enabling and requesting funding for, I'll say, newer interventions in forensic DNA testing. And so with that, again, with the request for the BDR, I'm asking just for the request for it to be turned into a bill and introduced. So with that, members, any questions? All right, I will take a motion. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Member Gonzalez. Any additional questions? All those in favor? Anyone opposed? And the motion passes. Thank you. With that, then, I will move on to our final agenda item, which is public comment. Again, public comment is for not making comments on the bill that was heard today, but for anything else under the purview of this committee. Again, asking speakers to keep their comments to 2 minutes, and please remember to state your name and spell it for the record. With that, I will open it up here in Carson City first for anyone wishing to make public comment.
Tanya Brown, TONJA, BROWN, Advocates for the Inmates. Thank you, Madam Chair, members of the committee. I know a few weeks ago, AB 63 was brought to your attention, and that was dealing with, and there was some discussion about compensation for those who have passed away posthumously. SB 66, I had brought to you and mentioned that as well. That was dealing with factual innocence, a posthumous petition. And some of the discussions that was being concerned, there wasn't really a whole lot of answers. But recently, on March 12th, during the Veterans in Politics talk show, I would ask that you go and to review it starting around minute 25, in which Nevada former retired Supreme Court Justice Cherry discussed wrongful convictions, and I found it interesting because they were asked about wrongful convictions and why, if a prosecutor withholds exculpatory evidence, why aren't they being punished? Well, he basically says that prosecutors, DAs will not go after DAs, and it is left up for the State Bar of Nevada who does the disciplinary action. So unless a law is created to disbar them, they're going to continue to get away with it, continue to practice, continue to go on to be a judge, a DA, a Supreme Court justice. So should something come up with the State Bar, perhaps something like this could be added to the bill or for the 2027 legislation. Please consider that. If you're sitting on the joint interim judiciary committees, again, think about what I have brought to you. Also, well, I'll keep bringing it back, but please go and listen to it. It's fascinating. They bring up the Fred Steese case, everything, and how far the DAs go to protect their own, and nobody's held accountable. And the State Bar won't go up against their own as well. Thank you.
Thank you, Ms. Brown. Anyone else here in Carson City? Not seeing anyone or anyone in Las Vegas. Broadcasting, will you open the lines?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now.
Anne Marie Grant, ANNEMARIEGRANT, private citizen, sister of Thomas Purdy, murdered by Reno Police and Washoe County Sheriff's Office. My definition of transparency doesn't equate to more tools to violate people's constitutional rights. And I'd like to add to what Ms. Brown said about the Veterans in Politics interview with retired Justice Cherry in his response to the question about wrongful convictions. And it makes sense as to why the Washoe County DA's office and the Conviction Integrity Committee have protected that false conviction over the years, because the prosecuting attorney who withheld the exculpatory evidence in the Klein case is protected to this day. The CIC unit is just a dog and pony show. Nobody's been exonerated through the Washoe County CIC unit. I'm still awaiting a my third public records request to get an update on how many cases they have actually reviewed, which is one true review and one that got no fair review, the Klein case, because Brady violations were alleged. So I'd like to urge you all to go watch that interview with Justice Cherry. It's very telling, and it really connects the dots as to why you can't get any justice in Washoe County. Thank you.
Thank you. Next caller?
Chair, the public line is open and working. There are no other callers to provide public comment at this time.
Thank you so much. Then with that, I will go ahead and close public comment. That concludes our business for the day. Thank you, members, and for everyone here that participated. With that, I will adjourn and see you all back tomorrow at 8 a.m.